Everybody, thank you for the invitation to speak here. I originally agreed with Damon that I would speak about the experiences of the Dutch Public Procurement Ombudsman, but we had a slight change of plan, so he asked me to talk about the subject matter of pre-market engagement from the perspective of an ombudsman, which I will do happily. First, some general remarks on the Dutch ombudsman, and then quickly I will move to the subject matter of today. I think I will skip some of the slides in the beginning, but they will probably be presented at the website later on, so you can have a look at them. We have a Dutch Public Procurement Ombudsman in the Netherlands since 2 years now, because the access to the ordinary civil courts is rather problematic in the Netherlands, particularly for small and medium enterprises. And that is why the new Dutch Public Procurement Act has the basis for establishing the Dutch Public Procurement Ombudsman. And its main objective is to resolve public procurement claims quickly, carefully, and accessibly. And we do so by analyze complaints and give non-binding opinions on complaints. We also have the possibility to mediate between the parties, but we seldom do that, because mediating between a contracting authority and a bidder in a competitive context is rather difficult from the perspective of the rules, of course. The organization is lean and mean, as you can see. There are only a few people working at the Ombudsman, and there's a lot of work to be done, which is why we will appoint a third member very soon. And interesting is that we have a lot of experts in the market, both coming from the market as well as from contracting authorities, who can assist us in delivering opinions once a complaint has been filed. Complaints are rather widely defined as any act or omission that falls within the ambit of the new Dutch Public Procurement Act. Complaints can be filed by any economic operator that is interested in acquiring a contract, and also industry organizations can complain on behalf of their members. And complaining is very easy. You just fill in a form in layman's terms. It doesn't cost you anything. You don't need a lawyer. And we'll try to do our best to interpret the complaint as we think it should be interpreted. And we will then try to deal with the complaint. We will refuse to do so if the contracting authority has not been notified beforehand on the complaint and has not been given a reasonable time to respond to it, or if a complaint becomes the object of a lawsuit before the ordinary court, because that can also happen. But if we decide to deal with the complaint, we will ask the contracting authority to respond to it and not to take further decisions in the procurement procedure. We have no power to halt the public procurement procedure, but in 60% of the cases, when we ask them nicely to halt, then they are willing to stop the procedure and wait for our opinion. And in the end, we will render and publish an opinion which is non-binding, but also there our experience now is that if we give an opinion in favor of the complainant, contracting authorities are more and more willingly to take the contract back from the market and to do their homework again. We were installed 2 years ago, and we have received 200 complaints until now. 90% is coming from the small and the medium enterprises. 60 complaints have already resulted in a non-binding decision, and 50% of all the complaints we rendered an opinion in, the opinion was in favor of the complainant. As we speak, we are being assessed. There is an impact assessment going on, and the report will be handed to Parliament it's expected in May, in the month of May to happen. When do we get involved in the procedure? Well, usually we get involved in the tendering procedure. That's where complaints are coming in. And the most common complaints that we receive have to do with the content of the documents. So specifications or selection requirements or award criteria, etc., have been drafted contrary to rules that can be embedded in the principles of non-discrimination, equal treatment, etc. Most complaints are about the preparation of the documents. And some complaints are also about how requirements and criteria are being applied in the tendering procedure. That too happens, but the bulk is actually on the content of the documents. What we see in our practice is that communication between contracting authorities and suppliers usually takes place in the course of the tendering procedure. And that is where we see a problem, in the sense that when the actors are in the middle of this tendering procedure, they are in, as I would like to call it, a procedural lock-in situation. That means communication is, of course, restricted as a result of the relevant rules. That's one problem. Another problem is that given these restrictions, contracting authorities have some fear of blowing up the procedure when they are being confronted with questions about the content of the tender documents. That leads to a certain kind of defensive communication, and that causes agitation in the market, and in the end parties end up with a conflict about the application of the rules, and then turn either to the procurement ombudsman or to the ordinary courts. That brings me to pre-market engagement. What we heard before from Paul, and this is also being, you can also find this, of course, in all kinds of research, is that everybody thinks pre-market engagement is a very good idea for reasons that it brings together in a more sound way demand and supply, in the sense that it helps the parties to eventually enter into a contract that will enable them to achieve all the goals in the end as regards quality, time, and budget. So it helps them to bring the parties together in a good way, and to assure that the supply will answer to the demand. Why contracting authorities are usually reluctant is Paul already mentioned that, is that in the pre-market engagement phase, particularly contracting authorities are afraid that pre-market engagement might lead to violation of rules that can be embedded in the well-known principles of procurement law. Why the idea of pre-market engagement is perhaps even better than we think it is that it can also help in making the content of the documents improve the content of the documents as regards the rules on non-discrimination, equal treatment, etc. Pre-market engagement could be a tool to improve these documents, and if these documents are being improved, that can further lead to conflict prevention, in the sense that all kinds of decisions taken in the documents, either as regards the content of award criteria or selection criteria, all these decisions are evidence-based on communication, in the sense that in the tendering procedure, contracting authorities can show, listen, I did this analysis before, and all my criteria are based on pre-market communication, and that may lead to a further advantage, that the communication on behalf of the contracting authority becomes less defensive because they know what they're talking about. And that could lead to more understanding in the market, and that could perhaps lead to less conflicts in the tendering procedure itself, which is also, of course, very costly business. The question then is how to achieve this. What I would like to stress is that the Articles 40, 41 in the new directive, they are not a prohibition on pre-market communication. What they merely do is they draw the lines, and you have to stay between the lines when you try to set up something like a device on pre-market communication. But then the question is, how can we seduce contracting authorities to actually get into this pre-market engagement? One could decide to leave it to the policy, the individual policy of the contracting authorities. One could think of self-regulation by the contracting authorities themselves, or one could think of regulating the best practices. What I would like to show you to conclude this talk is a small Dutch experiment which is going on. And it regards the operation of the principle of proportionality in procurement. One of the Dutch policy goals is, apart from implementing the directives in our national act, one of the goals is how to improve access of SMEs to the market of public contracts. And what we did is we codified the proportionality principle in our code, and we further detail that principle in a so-called guide on proportionality, which is based on a statutory instrument, and it gives us detailed prescriptions on how contracting authorities can act proportional when they take decisions either in aggregation of purchases, decisions as to what criteria to apply. And this guide on proportionality with its prescriptions, it reads like a code of conduct, but it has a certain degree of a binding character. And it basically works along the lines of the rule, you should comply with these prescriptions or explain why you not want to comply and why you have good reasons not to comply. And in explaining why you have good reasons not to comply, these rules, they steer on taking into account the effect of the procedural decision taken by the contracting authority, the effect on access to the contract for small and medium enterprises. And what we see is that if contracting authorities really want to explain why they do not want to comply, the only thing they can do so is to seek for an explanation based on pre-market investigation. And that's also what we see in the cases that are brought before the Ombudsman. Most of the cases on the proportionality guide are brought before the Ombudsman and not before the ordinary courts. We're not sure why that happens, but that's being investigated as we speak. And if we indicate in our opinion that the explanation given by the contracting authority is not adequate in the sense that it does not give sufficient support for the decision to use a certain criterion or to aggregate certain purchases, then we will give the opinion that the explanation is invalid and is insufficient. And what happens, I told you before, is that contracting authorities are more and more inclined to draw the contract from the market. What we hope and what we see already is that working with these comply or explain provisions can serve as some kind of a stimulus to contracting authorities to actually make pre-contractual communication work in order to fix their dossier before they actually approach the market with their criteria and their requirements, etc. That's what I wanted to say. If anyone wants to read more about the Dutch Public Procurement Ombudsman in English, there's one paper available yet, and we will talk about it further, particularly about the current research on the impact assessment at the Nottingham conference. Perhaps we see one another over there. Thank you very much.